There has been a lot of decision in European Court of Human Rights about child welfare cases in Norway. Actually, it has been decided on the merits in 42 cases, and in 23 of them, Norwegian were held liable. And these papers also is about the relation between European Court of Human Rights and Norwegian Supreme Court, actually. Since in child welfare, at least in Norway, the parents are accused and they have to defend themselves against accusations. So then we wanted to dedicate two things. How has the Supreme Court, Norwegian Supreme Court, reacted to all this decision by European Court of Human Rights? One of the main critics by the European Court was that the contact regimes were too restrictive. They did not facilitate family reunification and so on. Because before, the Supreme Court had made a lot of decisions, before this ruling by the European Court and also after. The Supreme Court in Norway has never given so little contact session as now, after the European Court rulings. So it's a little bit astonishing because it's supposed that the court should rule on every case, but it has to be an individual assessment in every case. The undercourt will always look to the Supreme Court, so actually the level Supreme Court rule or decide will influence all the court system in Norway. Since the level has never been as low as now, despite this ruling by the European Court, it means that the Supreme Court has not contributed to any improvement of facilitating contact as a method or a medium for family reunification. So we are actually still going in the wrong direction. How come that the Norwegian court system or Supreme Court does not change? So we try to look for what we call a paradigm, the paradigm in the judicial system. It has been some changes. It has been a big change when it's come to the wording. Like before, they always stated that the contact, that the care order would be long-term. After the European Court rulings, this is absolutely unacceptable. Every state is obliged to facilitate family reunification. So declaring that the care order will be long-term is absolutely obsolete. It's going out of the system. And instead, every decision made by the court states that family reunification is not given up. And this change actually, in the wording, we can think that it will change everything. Because it's quite opposite, long-term, and it means that you actually are giving up. And that family reunification, that you are not giving up. But it was two other reasons from before, which is still valid today in this court system today. And it's a theory that having little contact session it means that that should facilitate attachment to the foster parents. This is theory. Result is opposite. It's as long as you manage to have a lot of contact sessions with the biological parents, it facilitates attachment to the foster parents. And it's actually no surprise, because it is the parents who introduce grandparents, uncle, aunts, friends, babysitters. So it's even so accepted in science. We have this phrase which we say that the parents provide the safe haven for the child to establish new attachment. And despite this, the Supreme Court still says that we have to help facilitate the contact with the foster parents, and so we have to avoid contact session for a period. And then the child has negative reaction to contact session. It's always attributed, it's always the parent who is the one who is blamed. It's nothing about that the contact session is too to seldom. That could cause reaction, like longing. It's nothing about that the interim order were harsh or actually traumatized the child. The idea of European Court is that it is a contact session, actually, which is actually, as I said, the medium for family reunification. But the theory in Norway is like that then the child has negative reaction on contact session. We have to reduce contact session. And that could actually be the cause. So that could actually be the reason that the child gets this negative reaction when he finally meets their parents. Because then it's so much feelings. It's a kind of weakness in the court system because the judge is scared of doing something wrong. Because if they think that, okay, if we give the parents and child more contact, maybe the child will get even more negative reactions. So we are scared of doing something wrong, and then the system helps, tells them that they should not have so much contact session. So this is a kind of paradigm which is absolutely very difficult to just turn around. But as long as you have statistical tool and you have enough data, then you get this parameter about significance and so on, and we got significant result. The amount of contact session has never been so low as it is as now, and that result is significant. In the scientific society, I think response has been something like that. Now it's opposite. It's Norway which is ahead on the science. We understand. We take the view of the children, of a child. So we are in the head of this. And another interesting response is actually the dialogue between the European Court of Human Rights and the Norwegian Supreme Court, because the Norwegian Supreme Court, as I said, they granted several cases and ruled on the merits, and then the European Court were not satisfied with this. So the European Court of Human Rights also accepted new cases and repeated and more strongly said what it should be like. And maybe the Supreme Court adjusted a little bit, but not enough. But after 40 cases, the European Court of Human Rights raised their case. And what was actually the main issue where the European Court did go very, very far in saying how it should be, it was how much amount of contact session do you need if that should be, so we could accept that it will facilitate family reunification. A more time space than 1 week between each session is not sufficient. But it even goes so clear, and they did even go so far and saying that this is some kind of a fundamental to understanding European Convention Article 8 of family rights as a fundamental principle. They lift it up, and the Supreme Court did not follow it up. Did not a single case. We didn't indicate that this was actually a rule. Instead, we were going deeper and deeper into this exception that the child should not be exposed to undue hardship. It means that it should not be too much negative reaction on contact session. So they elaborated this exception of undue hardship, exception to the normal that you should have a lot of contact session. So, and this actually undue hardship has been a kind of a catchword in the Norwegian judicial system. So in all rulings with restrictive contact regime is always because that the child should not be exposed to undue hardship. So it means that we are in a paradigm where it's very hard to change what is going on. So we wrote a new law in 2022, but this law has still the same shortcoming. If the child is supposed to be reunified with the family, the law put forward a lot of conditions to be met. this condition to be met is higher and more difficult to comply with than removing the child from the family from the outset. So you have additional requirement, you have more condition to be fulfilled for family reunification than taking a child out of the family. This is a systematic error. The European Court for Human Rights is very clear about what is the best interest of a child. The best interest of a child is to maintain their family bond. What is the best interest of a child? And the first thing they say is that the best interest of the child is to keep its family bond. This is very clearly stated. In Norwegian law, you can maybe interpret it like this, but it's not stated so clear. The only place where it's almost stated like this is done in some kind of mystic manner. So you say that you can't actually, it's something else which actually disturb. I don't remember the wording, but it's absolutely downplayed this best interest of the child. This contradictory condition for reunification, which does not exist for care order in the first place. This is actually, for me, the most strange thing, you can say so like that, in Norwegian law. For me, I think that parenting alienation is more systematic in child welfare cases in Norway. The parents are very suspected and they are in very, very weak positions. We have a lot of this vocabulary in child welfare, which is absolutely new for the parents. They don't know about the attachment theories and so on. Despite they have a lawyer, the lawyer can never compensate for, because then the lawyer has also to be a psychologist. So they can't meet all this accusation done by the child welfare, and the child welfare is the funny thing. I think it's the same as family parenting, could be, that actually is introduced a lot of terms which is not scientific. A lot of blamings are like mentaliseringsevne in Norwegian, mentalizing ability. All these words, terms in this field is not scientific. We have this diagnostic manual made different classification and illness and so on, psychological mental illness. And then in these cases of custody with child welfare, we introduce new terms, new kind of diagnosis, which is actually not scientific. And the parents can't defend themselves against this. They don't understand what it is. So this is actually a very systematic bias. In Norway, we have a kind of double duty. First, we should help the family, and secondly, they should care order, and also interim order, interim care order. This kind of double obligation or duties is a big problem for the services. They can't handle it, because it means that in one point you always start trying to helping, but at one point you are a human being working in this office, and in one point you get tired of this hopeless women, these hopeless parents, and then everything changes, and then you actually are not helping. So all this authority about putting forward the care order and so on should be stripped from the child welfare service, putting to, when it's about sexual abuse, when it's about drugs, then it should be the police, which is the expert on it, who should put the care order, have the authority to make a care order. If it's psychiatry or also drug, could be, and so on, it should be the health services who is expert on that. And I think that since they are expert, they will not make this error about introducing new terms, new vocabulary, which has no scientific basis. So it will be more professional. And then probably also the child welfare service will be fighting for their families to the very end. And actually that's what they need, because they are so weak. Of course, this is hopeless parents, this is hopeless mothers, but it doesn't mean that it helps to remove the child from them. You still need the home. It still needs their siblings. They still need their mother, or father, or what it is. So this is the last stance of security, and then you remove the last stand of safety, and the very last thing it has. Putting into a new family, of course, is traumatic. It's very traumatic for a child. They should never giving up of finding new way of helping the family.